mediate that. But if it does occur, we would take like 5 minutes to try to get the webcast back up. And if we're not able to do it, then we are going to proceed because we do have a rather long agenda and we don't want to go over certainly to tomorrow morning. So having called the meeting to order, Kim, would you please take the roll?
Sure. Esther Lynn,
Here.
Anjali Agaptep, James Bolton, Robert Brody, Alex Chen, James Efting, Judy Gillespie, Karim Gongara, Dolores Heisinger, Michael Iseri, Larry Kaplan, Paul Kramer, Alex Lawrence, Bethany Pick, Vince Reyes, Judge Sherry Torrealba, David Torres, Patricia Villalobos, and the chair.
I'm here. Okay, we do have a quorum. Next on the agenda is a call for public comment. Is there any member of the public who wishes to address the Committee of Bar Examiners? Seeing none and hearing none, the next item is the approval of the minutes of our April 26th and 27th meeting. You have that as part of the attachment to the agenda. Are there any corrections or changes that anyone wishes to make? If not, a motion to approve?
I will move to approve the minutes.
Okay, motion and a second. Any further discussion? All in favor, say aye. Aye. Opposed? Abstentions? Okay, thank you very much. The next item on the agenda is the report on key statistical indicators for April of 2019, attachment 101. Amy.
Good morning. With my, okay, thank you. This looks like Christmas lights. All right. So good morning, everyone. I'm going to discuss the key statistical indicators. As you know, this is a standing agenda item on the CBE agenda. At the last meeting, there was a request for us to include statistics on the Law Office Study Program. We're still working on incorporating those into this report. There are a few items, statistics that I'd like to highlight, and they're trends that I've highlighted in the past. As was indicated in previous reports, we've had a decrease in the number of applicants placed on the motion, the number of applicants for the general bar exam, and also for the first year law student exam. At the last CBE meeting in April, I also reported a decrease in moral character determinations, PTLS, this is our practical training for law students, and Pro Hoc Vice. That was the first time that had happened, those statistics amounted to a decrease. But I also explained that the conversion into Ames contributed to that, but because what we had was a backlog in our data entry of paper applications into the new system, and that contributed to this. So at where we're at right now is that we are almost caught up with the Pro Hoc Vice applications that is entering them into our new Ames system on paper. So that the decreases we've caught up with that, and so we're looking more like on an average, which has been that Pro Hoc Vice has been increasing throughout the years. We also continue with the increase of the number of moral character applications as a result of MJP practices. So this is a multi-jurisdictional practice. Those moral character applications have increased. And also the number of attorney and law student applications has increased when you compare those numbers to last year. All right, any questions about the key indicators? All right, great, thank you. The next item that is under my report is the schedule for the August 23rd meeting. It's been attached there, and I just want to highlight that this is a 2-day meeting. The second calibration is scheduled for that Saturday, the 24th. So that is included in this 2-day schedule. All right. The next item is about the California bar exam. So in July, the July 2019 California bar exam is scheduled for July 30th and 31st. We have approximately there we go, 9,100 applicants approximately that have registered, and we are assessing for eligibility. And you're all invited to come and observe that bar examination. We will be at 13 testing facilities across the state. Kim will be sending badges to committee members. So I invite you and strongly encourage you to come and witness our staff in action as well as our applicants in doing under examination. So again, there are various locations. We have the July 30th and 31st, but at testing accommodation sites, these are extended. So there's a possibility that you could come on August 1st if you attended an extended day testing accommodation site. Any questions related to the bar exam visits?
You missed number one.
Oh, sorry. So CAPA, I missed that topic. So to talk about CAPA and to jog everybody's memory, this is the job performance study that we're undergoing right now. We just had a meeting this week, and Robbie is going to give us an update. He is our representative from the CBE on that committee.
Good morning, everyone. So as you know, I am the CBE representative on our practice analysis working group, which I must say, getting very exciting. It's awesome. Our group, which is composed of judges, attorneys, and public members, have actually drafted the survey that's going to go out. The beta testing has been completed just recently as of this week, and it's fantastic. So you know the idea, this was at the direction of our Supreme Court, was to look at what attorneys do, and then we can look at the bar exam in relation to is that an accurate or best test for the things that attorneys do. We're already seeing from our beta testing some very interesting results. It's going to be awesome, and this survey is being presented for the CBE's review. What we will do with the results remains to be seen. We may see some indicators for a lot of what we call soft skills that we don't currently test on. Anyway, it's very exciting. It's really coming true. What is coming next is the campaign to encourage I just think it's fantastic. So, anyway, speak about this, the survey will have been launched.
Yes, so I just want to highlight a couple of things that, Robbie touched upon. That is, the two surveys that, survey modes that are undergoing, that are part of the CAPA method, the CAPA surveying process is the ESM as well as our traditional survey. Robbie referred to the pings that he's getting. That is the ESM. And what it involves is getting these pings where you answer a few questions. Robbie, do you recall how many questions you get in response to each of the pings?
Just one or two.
So it, again, the effort is to gather as much information about the knowledge, skills, and abilities so we can determine what is the minimum competence or minimum requirements for entry-level attorneys. So between the ESM mode and the traditional mode, which is a lengthy survey, do you recall, Robbie, how many pages the traditional survey is approximately?
Sorry, the traditional survey, and again, we're really looking at what do lawyers do? What skills do they use? The hope is to capture new attorneys, the ones that have, most recently taken the bar exam. The traditional survey would take about an hour to complete. It's daunting. It's not nothing. A lot of information about your practice areas, and when you get one of these surveys in your email, no matter who it's from, you think, wow, it looks like it's just been there forever, but we have actually prepared it ourselves with the help of the survey vendor that we've been working with, the Scantron vendor. So that takes about an hour. And the pinged ones, what activities you're doing, what is the importance of that activity to your practice, I think is going to be very interesting. And I think, it's a first for us, but it's going to be worthwhile. I think the Supreme Court, who, directed us, is going to be pleased to see the wealth of results that we get.
Yes. And then also preliminarily, I think in the results that we've captured from the beta testing, the onboarding survey, so the traditional method has had already produced a lower response rate than the ESM. So I think both methods will really enhance our data collection process. The other thing I wanted to mention was that overall, all California licensed attorneys will be getting an invitation, but there are 3 separate categories. So you might be invited to participate in the traditional, you might be invited to participate in the ESM. And then lastly, just want to remind everybody that the National Conference of Bar Examiners is also conducting their own job analysis, and there's a chance that you'd be invited to participate in that. So we're ensuring that there isn't an oversaturation of surveys going out to licensees, and by this sampling method, we're able to control for that. So, and as Robbie highlighted too, the findings will be presented here, preliminary findings in October. So we have scheduled that for our agenda. So thank you, Robbie. Anybody have any questions? Oh, there we go. An hour. Yes. All right.
Does the state bar, does the state bar president still have monthly meetings with the local bar presidents?
I'll answer. I think I'll share this microphone.
What I'm talking about, perhaps they could distribute that information to them, and we work also closely with the local bars to try to encourage the attorneys to participate.
Absolutely. So the California Lawyers Association has taken over overall responsibility for those monthly calls with the local and affinity bars, but the state bar does participate in those calls, and we've been talking about the practice analysis through that avenue for many months now. In terms of the outreach strategy. It's going to be multifaceted. So the chair of the board, Jason Lee, will actually be sending we're going to take the step of sending hard mail letters to all law firms and government agencies in the state that are enrolled with us for agency billing. This is a new thing we have in place that automates payment of the licensing fees for organizations. So this letter outlines the importance and significance of the study and asks each of these entities to ensure that all of the attorneys in their organization actually participate. In addition, we have a pretty exciting, I think, for the State Bar social media campaign planned. And in fact, you may hear a little bit more about it later today as we're filming at a studio here in Los Angeles. The video that will be used to form the basis of the campaign that will be launched on LinkedIn, Instagram, trying to reach those young attorneys. Facebook, etc. So there's a lot of different ways that we're trying to outreach, working through CLA to reach the local and affinity bars will be one important component of that.
Thank you.
Just a quick comment, I guess. I know that the Legal Aid Association of California, OLAC, they're sending out a survey that's an hour long. And I think the California Lawyers Association is also looking into a survey that's pretty much an hour long as well. So I'm just really concerned about the fatigue of over-surveying people to death. But I know we're giving them credit, so that's more incentive. But I just want to preface that different organizations are already going to be sending them out, and I fear about the competition / people's times, and just one person say, "Oh, I did the LAC one. Why am I doing this again?"
Really have a problem with that internally because we also have the Justice Gap study going on here. And I'm not sure if that's the LAC study you're referring to. We're partnering with LAC to do another survey of law students specifically related to the Justice Gap study. But we've also been talking about doing another survey to find out about attorneys' career choice decisions with respect to going into legal aid practice fields of work. So we're trying to work on it internally. I think your comment is well taken. It's a challenge.
The next item's related to remote proctoring. So as you may recall, staff requested for approval to pursue remote proctoring for the upcoming June first year law exam, and then also for the California bar exam. We also went to the board in May and received approval for piloting. We needed to investigate the ability to meet the Wi-Fi requirements for this. And in that process, which took some time, our vendors decided that they wanted to take more time to fully test the system, which we're really happy with, so that we have we have greater exam security for both the first year and the California bar exam. So essentially, we will be piloting, but we will not be piloting for this upcoming first year exam, which is next week. We will be piloting for the for the October first year. So it's October 2019, and eventually for the February 2020 California bar exam. So we are still pursuing remote proctoring. We're not just doing it soon. We're going to do it in the fall. Any questions related to that? All right, thank you. Oh, yes, so we had our first moral character working group, and we have a CBE member appointed to that working group, and he's going to report on our first meeting. So Larry Kaplan, please.
Thank you. Thank you. So the Moral Character Working Group met, I guess it's 2 weeks ago in San Francisco, and it was preliminary. It was the first meeting, so it was sort of a lot of time was just spent on, where we are and where we're going and all that stuff. We were presented with an overview of the process, the moral character process, the standards, We were given a short overview of the history of the moral character process, along with a few landmark cases. Staff made a presentation. We got a chance to see the standards that they used back in the day. Some folks think, I'm one of them, believe that long ago, moral character process was a tool of discrimination. In addition to other things, which obviously it's evolved from that. And that was all talked about in the history. We discussed our priorities, what needs to be changed, and what's working so far. The law school deans who were there had a lot to say. What impressed me about what they said was that they need the bar to provide greater transparency and information and education to them and their mostly to their students, well in advance of going through the moral character process. They said we're not fully educated enough to provide the information that the students need to be prepared for the moral character process. So that was identified as something we need to do a better job at. Debbie Muracal is also on the moral character working group. As you know, she has done a lot of research into moral character issues around bar admittance. And she said it was important to look at issues around applicants who have criminal records, issues such as rehabilitation, remorse, community service, and come up with ways to address obstacles to people in that situation. There was some discussion of the informal conferences. Currently, guidelines and procedures are being developed to reflect the new reality of the way we're changing the process of informal conferences. And we talked about the importance of consistency and accountability in that process. And that was basically it. We identified what we want to do next, and we're going to meet in August.
Great, thank you, Larry. The next item is an update on CS bars. So we've had 2 meetings, and Kareem Gongara is our CBE member that's assigned to that. We knew he was going to be out today, so Natalie Leonard will be presenting on those meetings.
Sure. So I'm glad to report that Kareem was able to attend on behalf of the committee, and he's looking forward to returning to the next meeting. And so he left me with some comments that he wanted me to share with you. So this is the second meeting of the CS bars, and it consisted of a number of staff reports and a number of discussions as well. We talked with the CS bars about the law school assembly, and this will serve as the report to this committee about the law school assembly as well. This is the first time that the State Bar has gone through with an enhanced agenda for the law school assembly, held north and repeated here south. You heard a preview of this at the last meeting, and we talked about the items that are front and center for you, some of which you've heard about here, but we were also able to engage the deans to get their feedback on issues that you talk about all the time, such as CAPA, partnering with the Office of Access and Inclusion to talk about the LAC study that Leah mentioned, talking about how to reach those law students that don't read email anymore, which is something that we were told loud and clear. And we also talked with them about some initiatives that they have related to loan repayment, public interest, and retention of diverse law students. In addition, we talked to them about the Moral Character Working Group, and right away we were able to use some of the feedback that we got regarding the Bar Strategies and Stories program. We learned about how we could partner with the deans to increase the engagement of students and increase the ultimate signups for that program that is taking place now for those students registered for the July 2019 bar exam. And as you know, the State Bar already conducted a very successful pilot of that program, but what was really needed was an increase in the number of students. So we greatly appreciated the Dean's partnership in helping the State Bar to reach its goal in that way. In addition, we talked about the release of the MPR forms for the minimum cumulative pass rate for the Cal schools, and that will be coming into the State Bar July 1st. We'll spend July verifying those numbers, and then we'll present them to you at the next meeting. We also discussed with the deans the quarterly e-newsletter that began in May and is sent specifically to deans. That's something we could make available to you during the lunch hour if you would like to see that. And we talked about something we'll discuss later today, so I'll be brief now, the release of the amendments to the accredited schools related to accreditation of fully online schools. Finally, we're continuing to work with them in a working group style about the ways that we can enhance our demographic data collection to help provide resources that can improve student outcomes. In addition, we are starting a very large project that will take the balance of this year related to creating a deemed accredited status. This will be an alternative to the Cal accredited status for those schools that are able to earn a regional or national institutional status. We were very happy to have with us the WASC president and vice president to join and also to give their advice and perspective to the program, and we look forward to working with WASC throughout this process. And that's what we discussed at CS Bars. Any questions? Thank you.
All right, so in terms of other recent developments, we might have something after lunch, but at the moment, that's all we have.
Next item is examinations report on the draft of the Supreme Court in February 2019 bar exam.
Thank you. This is the time and place set for the examinations. Report on the draft of the Supreme Court. I'm going to defer that to Amy. It's on 0200. Amy?
All right, so we prepare a report to the Supreme Court after every exam administration. The one attached to the agenda today is for February 2019. We report on the number of attendees, distinguish between how many were laptop, how many were writers, our testing accommodation statistics in terms of number of attendees. We also report on our grading process, our calibration process, and this is a review and receive, so we're hoping that the committee approves that process.
Thank you very much. Is there a motion to adopt the Supreme Court report on the February 2019 California bar exam be finalized and submitted to the court? It's moved by Brody, seconded by? Seconded by Peak. All in favor? Aye. Any opposition? Any abstention? Seeing none, motion carries. Let's now go on to the discussion of the 2018-2019 examination goals, which have been attached on 0201. And after we agree to these, we are going to have a presentation. So this is one of the things that we've previously discussed in meetings. Has everybody had an opportunity to review, and are there any questions with respect to the exam goals? Seeing none, is there a motion to adopt?
So moved.
Moved and seconded. All in favor? Any opposition? Abstention? Seeing none, motion carries. Let's go on to the training on the processing of testing accommodations and petitions, and on substantive issues concerning evaluation, testing accommodations, petitions. We'll go to Lisa Cummings and Lynn Taylor.
And can I remind everybody to speak into the microphone, please? Thank you.
Can you hear me now? Okay.
Good morning, everyone. Thank you. This is going to be a presentation on the nuts and bolts of the processing of the testing accommodations petitions that we receive in the Office of Admissions. I have with me here Lynn Taylor, who's sitting to my right, and Lynn is the program supervisor, so she oversees the day-to-day operations in terms of the processing of these petitions, and she'll be kind of splitting the slides with me in terms of presenting. So, let's see, the number 3, yeah. So the purpose of testing accommodations, with regard to what we are supposed to be doing, we have to comply with the ADA, the Americans for Disabilities Act, and in order to ensure that individuals with disabilities have the opportunity to fairly compete for and pursue educational and employment opportunities by requiring testing entities such as the State Bar of California to offer exams in a manner accessible to persons with disabilities. The testing accommodations, what they are changes to the regular testing environment and auxiliary aids and services that allow individuals with disabilities to demonstrate their true aptitude or achievement level on standardized exams or other high-stakes tests. And obviously, the California bar exam is a high-stakes test. And the general goal of providing testing accommodations is to create a level playing field for candidates whose disabilities or language abilities may adversely affect their ability to compete on a test. So what I've underlined in this kind of long slide is that what we look for are reasonable accommodations, and that's what the ADA requires. It requires reasonable accommodations and to address the functional limitations that applicants have. Again, the level playing field that I mentioned before in the previous slide. However, the other considerations that compete with that are that we have to preserve the security, validity, and integrity of the exam, what we're trying to test. And anything that, an accommodation that's requested that may fundamentally alter the nature of the exam and or pose an undue burden on the State Bar, the ADA does not require us to provide those.
So some examples of our more common accommodations are extra time for one or more sessions of the examination, for extended days of testing, for testing in a private or semi-private room. Sometimes we'll also have requests for specific seating near a restroom or an exit. Permission to dictate the answers to the examination to a typist or to speech recognition software, or special versions of the examination questions. This could be Braille, large print font, audio recording, Word document on CD with the questions to be used with screen reading software. Another common request for accommodations is permission to bring in specific items to the exam, whether it be food or drink, a special chair, items like that. A complete testing accommodation petition consists of the application itself, which is now available in our online community. As an alternative, and especially for some people who have certain types of disabilities, this isn't possible, so we still accept the paper application received by mail and processed manually. Along with the application itself, we require a personal narrative. And this is really the applicant's opportunity to explain to us in plain language what it is that they experience as part of their disability, how it affects them in their day-to-day lives, and what specific accommodations they need based on that disability specifically for the examination. Along with their own application for accommodations, they need to submit supporting documentation. We have different forms for different types of disabilities. Our Form B is for physical disabilities, Form C is for learning disorders, D is ADHD, Form E is for psychological disabilities, Form H is for visual disabilities. In each one of these forms, there is specific requirements as far as who may complete the form on the applicant's behalf, as well as the supporting documentation that's required to be submitted along with this form. Each form is a little bit different in the requirements that are outlined in that form. Along with that, we also need verification of any accommodations history that the applicant has had, specifically for accommodations that they were granted in law school or for a bar exam in another jurisdiction. Also, we encourage applicants to submit any additional documentation that may help them make their case as far as their need for accommodations, whether that be transcripts, previous evaluations that were done in elementary school, junior high, earlier education, any results of standardized testing, letters from their family, You know, sometimes if they don't have a long history of accommodation, it may be notes from their physical therapist, anything that might help them, we encourage them to submit. We find that we often receive incomplete applications. So we have tried to put together a checklist outlining exactly what is needed. I know this is impossible to read. It's impossible for me to read right here. But it has proven helpful in giving the applicants a checklist to go through and make sure that they're submitting all of the required documentation. As noted on the bottom, again, I know it's difficult to read, but this is the minimum required documentation. The committee may go back and ask the applicants for additional information. Also, there's a note here that it is the applicant's responsibility to be aware of these requirements and to submit a complete complete application for accommodations.
Okay, so this is just sort of in a nutshell the processing of the day in the life of a testing accommodations petition or application. So you start with the application being submitted. The staff will review the application and the accompanying documents to determine whether or not it's complete. If it's not complete, then staff notifies the applicant with regard to what is missing, what's still required. When that application becomes complete, it is initially reviewed by staff, and staff will sort of put together a summary and make an initial staff recommendation based on the documentation, and that is if the file requires consultant review, which is many of our files, they are sent by secure email to one of our consultants. There may be multiple consultants involved in a review of a file, and that is certainly primarily in a case where we have multiple disabilities. So many, I don't want to say many, but lots of applicants have submit their petition based on multiple disabilities. The other situation where it could be sent to multiple consultants, even if there's only one disability, is if the first consultant who's reviewed it has recommended denial. We give the applicant another opportunity and send it for sort of a second look. And then after that is done, the consultant reports and recommendations come back. And that, again, the staff would summarize the file and draft a preliminary recommendation and refer it to executive decision. So it comes to me first, and I review everything, and then I either modify it or accept it, and then I send it off to the director, Amy, and Amy makes the final decision. She reviews the file also. So there's many touch points to the process. So again, this is sort of a rehash, but there's a few new things in here. The committee's role in this, and I'll in a slide that I'll get to next, I'll describe what it is that the committee does and what their involvement is in the appeals. So basically, with the I think the result of the initial review of the petition would be either to grant the applicant's requests in full, or to partially grant which means they don't, they're not granted everything. It may be modified. It may, some of their, for example, if they are requesting double time, the recommendation may be to grant them time and a half. And then the third possibility is to deny it, the petition outright. So they would not be granted any of their accommodation requests. So basically, if there is the applicant then has an opportunity to appeal that decision, and if it is it comes back to then the staff. Staff then reviews and makes another recommendation, goes to me, then goes to Amy, and an ultimate decision is made for a recommendation to go to the committee. If it's a full grant, then the applicant just gets a modified decision letter letting them know that your appeal has been granted, that you're getting everything that you requested. If it's either a partial grant recommended by staff or a denial of the appeal, then that's when it goes to the Committee of Bar Examiners. So this is the appeals slide. So appeals for a particular examination, so for example, if the applicant is appealing for the July 2019 bar exam, the drop dead deadline for that is to file their appeal by the first of the month of the exam. So for the February exam, it's February 1st. For the July exam, it's July 1st. And then also for the first year exams would be June 1st and October 1st. The appeal should present new and/or additional information that hasn't already been considered. Sometimes applicants will resend exactly everything that they said before. That is not going to get you to an appeal because there's nothing new for the committee to base a change in decision on. So when appeals are received, whenever possible, if it's an appeal that involved a consultant review to begin with, it's referred back to the original consultant for a follow-up review with all of the additional information that's being presented. Because a decision must be made and communicated to the applicant in sufficient time prior to the exam, the appeals filed on or near the deadline, which we get a lot of, are processed at an extremely tight deadline. Because the committee does not meet in person between the first of the month of each exam and the end of the month, which is when we tend to have our exams, the committee's yearly meeting schedule always includes the conference call meetings that are going to be in between those two dates. Yeah.
About the notion that new or additional information has to be presented, there you say should, which is not mandatory, but are you suggesting that an appeal would not be considered if there was no new information provided?
We would notify the applicant that they would need to have new and/or additional information. A lot of times what those situations are the applicant is challenging the committee's processes and procedures. They're challenging, they're making completely 100% legal arguments.
Okay, but I guess my glib response is, so what? Don't they have a right to get their concerns heard by this committee? In other words, could this rule be used to stop a staff decision from ever coming to the committee?
With regard, if it's solely legal arguments or solely arguing with the committee's processes and procedures, sometimes when it's solely legal arguments, we send it to council to review. If you want to change these procedures, if the committee would want to change the procedures and want to start hearing applicants who basically have no new and/or additional information, the committee can propose it and we can.
Okay, well, so that current approach assumes that the committee and the staff and the consultants are always of one mind, which I don't understand that to be our role. We are publicly appointed people to apply kind of a general set of values to the work of staff. And if we're not seeing simple disagreements with what staff has done to date, I think our role is really diminished, although I will note that that is a trend that I see happening in a lot of places with regard to the committee.
Can I just insert an idea here? So the reason the rule exists, that is that when we make a determination and it comes to an appeal, and that appeal information or the new appeal application does not contain more information than the initial determination, we ask for that information. So our initial determinations are not being second guessed. I think what we want to bring to the committee is any information where a determination needed more information, needed more, we didn't know anything, or information that comes to light after that initial determination based on the data that was, or the information that was presented initially. So I think that you're suggesting that we bring all of those forward, but it would be just challenging the initial determination with the same information.
Okay, well, if it's if it's a determination of the committee that somebody simply wants to bring back to us for reconsideration, I see that as a different matter. But if this person's request has never been before the committee, to say that you have to come up with new information that you didn't provide to staff, before the committee can ever hear about your case, that seems unreasonable to me.
So, so Paul, I just want to make sure I understand. So, in terms of if all the applicant is doing is challenging the committee's established standing procedures, the committee wants to be able to revisit those procedures on a regular basis, or?
Procedural requests, maybe not, because they can go to I guess they can go to the state bar court, or can they?
No, they go to the Supreme Court after the committee,
Okay,
but, okay.
And that's another role that we serve, I think, is we're kind of like the final, because these don't go to the Board of Trustees, we're the final check to make sure we haven't just screwed up royally before somebody has to take us to the Supreme Court and you know, where things get ugly, it's hard for people to compromise, and we might end up paying an attorney a lot of money.
Okay, so,
Could I make a suggestion, Lisa? Because I understand completely what you're saying, Paul. And I would ask that perhaps we consider referring this to the Office of General Counsel to review the legality, especially in view, and there's Strumsky versus the San Diego County Employees Association, case from 1974, which talks about vested rights. And if you're doing administrative mandamus review under 1094.5, it requires that the court, in reviewing that, determine whether or not there has been an abuse of discretion. And so if staff were theoretically to be accused of abusing its discretion and the record is complete, I'm not sure why it should not come to the committee. So
Okay,
I
yeah,
would
it does
ask,
sound like a question for further study.
I think that it is, because there are some issues relative to the standards that are used in determining abuse of discretion. And I think that that's really a role that the committee could play.
But the other part of it is staff and the consultants make value judgments. And if the applicant has presented a complete record to them, I don't think in order to get it before us, they have to submit a more than complete record. One of our roles is to review the judgments that staff and the consultants make.
Yeah, and there are also cases that talk about whether it's a de novo review or if you're just locked into the record and the findings that had been previously made. So I would ask that we refer this to OGC.
Instead of saying should present, suppose you say may present. That takes away the requirement. Should present new information. Instead of saying should, say may present new information.
Yeah, and it sounds like that would be a change of the rules, because what I'm hearing from Lisa is that should in this instance really means must, according to our rules. So yeah, and we're not looking at the language of the rule itself. This is just a summary. But it sounds like you're inclined to say that they don't necessarily need to give new information.
okay. Any other questions? Yes, Dolores?
One thing I'm still not clear about, when an applicant submits a petition, the original petition for accommodations, and staff checks to see that all the information is complete and it's ready for some kind of determination, does staff make some determinations on some issues and send the petitions to consultants on other issues, or do the consultants see all of the petitions, or what's that process?
The consultant sees the entire petition.
For every single applicant that petitions for special accommodations?
No, not every single one. It's the learning disabilities, the ADHD, the psychological disabilities, the visual disabilities.
Okay, and so the ones that don't fall in those categories are decisions made by staff?
After research, yes, they're recommendations and decisions made by staff.
Okay. So what percent of the petitions go on to the consultants? Generally.
Ballpark. Probably 70%. So Lynn estimates about 70%.
Can you hear me?
Yes.
Weird. How do we typically tackle fraudulent disability accommodation requests? An issue that seems to have happened before, at least in 2012.
I'm assuming you're referring to the college admissions scandal?
No,
or something related to it?
No, I discovered in 2012 one of the, I think, Hastings Law School student submitted fraudulent requests. But my question is more broad. Do we have any mechanisms in place to tackle fraudulent disability accommodation requests?
So can I suggest that we talk about this in closed session? Because to the extent we start talking about individual accommodation requests.
We're not talking about any individual, just broadly mechanisms and the process. If we have such a process, is this something we can discuss?
I mean, I don't know if you have an answer to that, Lisa.
I mean, generally, we don't question, we don't have the ability, or we shouldn't be questioning the diagnosis itself. I mean, we don't go out there and police. I mean, if we get indication that there might be something fraudulent going on with respect to perhaps, say, for example, a specialist who's out there who is for no basis, no professional basis is doing a lot of these and giving a lot of, recommending a lot of testing accommodations to people who don't really truly deserve them, then we will kind of might flag them or something. But at this point, our consultants are asked as part of their review to consider whether or not there's any basis for making for the applicant specialist, and it is mentioned in some of our reports.
And can I just add, though, in response to Alex about the entire process is set up. It's not one approach that we take in terms of assessing whether something's fraudulent. There are a lot of documents that are required as part of the process. Between that and the use of consultants, I think, is a way that we can determine fraudulent, and I don't even think we put it in that category, but valid, justifications for a testing accommodation in general. So I don't think there's one approach. This whole process is designed for us to be able to validate these applications and justify the merit of the request.
And Alex, I knew also that jurisdictions do share information when they find out about an applicant who is applying to multiple jurisdictions. If there's one that is applied to their jurisdiction that they find out that they had a fraudulent testing accommodations petition, they will notify other jurisdictions. We can get possibly flagged that way.
So I take that as we don't authenticate, we don't verify any documentation submitted by applicants. We're taking as face value, those are the records.
Unless there's something that indicates to us that might not be, it might be fraudulent.
And to that extent, if someone is found to provide fraudulent documents, would that individual be referred to the Moral Character Committee?
Yes.
And to that extent, do we have any statements on the application stating that if anyone is found to provide those documentations, that they would be referred to us as such and such?
Yes, there is at the end of the form, there's a verification that the applicant's required to sign, and included in that paragraph, it indicates that there's anything that's found to be fraudulent or untruthful, that they will be referred to moral character.
Okay. I don't think it's entirely, it's not a perfect safeguard, but I do understand the amount of burden that is required to authenticate and verify every single document coming through the consultant and the staff. But I right now, I just don't know how to resolve this potential problem, which seems to be real.
You'll hear from Lynn about the volume. Yes.
I guess you're not at the end of your presentation, because I guess my question would probably reflect back about 2 slides ago. Starting with the beginning process of when staff gets the application. So how many people are on staff to review these applications?
4.
4 people, and I forget how many applications are submitted for consideration for testing accommodations?
Right now, for July, we've received over 800 applications.
And the kind of training that the staff gets to be trained to look for accommodations, appropriation, whether or not they're appropriate, how are they trained to do the review?
On-the-job training.
On the job.
And if I could jump in, this initial review that we're talking about is primarily to make sure that the forms are signed, that the appropriate documentation is there. It's not really a comprehensive evaluation of all of the content. It's more confirming that all of the pieces are there.
Okay.
Everything's been completed by the appropriate specialist. All of more checking boxes than making a determination.
So when I look at this slide, it goes complete, initial review by staff, and then the big center square implies that it is now sent for consultant review. But I think we just heard about only 70% of the files are sent for consultant review. Is that correct?
The remaining ones may be physical disability reviews.
Or, sorry, we also have the same accommodations. That's part of that, that contributes to that number too. So that is people who have a permanent physical disability that we just gather new information and then move forward. So perhaps somebody, with a missing limb or something like that, we wouldn't require that the person start that whole application process all over again.
Yeah, those are people who have had the application, their accommodations approved for a previous exam, as long as it's not more than 5 years. If it's been 5 years before since they've had their previous accommodations, we do usually require updated information. And we're talking only about permanent disabilities.
And how do you review for permanent disability?
If it's somebody who has generally who has a ADHD or a learning disability, something that is generally there since childhood, throughout their lives, things like Amy mentioned, a missing limb, things that would objectively be something that you wouldn't necessarily change over time.
Okay, thank you.
Does that conclude your presentation?
No.
Oh, okay. I'm not cutting you off.
Okay, so regarding processing times and important deadlines, there are rules about our process in the admissions rules, particularly that states that an applicant who has filed a petition for testing accommodations in accordance with these rules, meaning that they have filed a complete petition that meets all of the, satisfies all of the guidelines, that they will receive in writing notification if additional information is required within 30 days, and within 60 days of receiving that file complete, they will receive a determination or notification that action is still pending on their request. The deadline for filing an application for testing accommodations is the same as the final filing deadline for the same examination.
And what is that?
For the July exam, that was June 3rd. The appeal deadline, as Lisa mentioned earlier, is the first of the month of the examination. We also have a category identified as emergency petitions for those disabilities identified after the original deadline of June 3rd for the July exam. But there's also a limitation there just as far as what we can accommodate for the exam that's approaching. So that deadline is at least 10 days prior to the start of the examination.
I just also want to add that Lynn mentioned that June 3rd is this year's July application deadline. Statutorily, it's actually the first of the month prior to the month of the exam. So it really was June 1st, but because June 1st fell on I believe it was a Saturday or Sunday, that June 3rd was the first business day. So that's how we would do that. The rule is really the first of the month, but it's June 3rd this year for July.
And for petitions coming after the deadline, what do we do with them? Do we automatically deny those requests?
We don't accept them. So we review them to make sure that it doesn't qualify for an emergency petition, and then we notify the applicant that it was received. We will also try to help them as far as to let them know if there was any missing information, should they wish to apply for a future exam, so that they already have that information and can start collecting anything missing to apply later.
But for that administration, it's automatically no for them.
Right. It's just not accepted. It's not denied. It's just not reviewed.
Not reviewed.
So do the bulk of the petitions come right at the deadline?
Yes.
So there's no real good opportunity to spread out the work?
I wish there was. So some common issues that cause delays in processing. We do receive a large number of incomplete petitions. If the applicant didn't sign the release, the cover page of the form of the supporting documentation that they provided, we ask them to do that. If their specialist didn't sign the form, we ask them to send it back to their specialist for signature. A lot of times we receive supporting documentation that is clearly completed by the applicant and then handed to the specialist for signature. So we will ask them to go back and actually have their specialist complete the form. I know that a lot of time, I don't believe that this is in any way an attempt to be misleading. I think the specialists are busy, and so a lot of times they'll probably ask the applicant, just complete the form, tell me what you want, and I'll sign it. So we do ask them to go back and have the specialist complete the form for them. The missing personal narrative has been a big issue, and we made a lot of effort in thinking about this new Ames application, how to bring this repeatedly to the applicant's attention, because this is really critical as we review their application to understand how their disability affects them personally. We review all of these applications on a case-by-case basis, and where I think applicants a lot of times will think that, well, I've told them that I have MS, and so these symptoms are common to everybody. They're not common to everybody, and we do need to know exactly how they are affected by their condition and how it will affect them specifically on the examination. So we have seen some improvement there. The other way that the online system has helped is that we can, rather than waiting for the application to come in the mail, we can review it instantly and respond, in some cases within, a couple of hours to let them know what's missing. And especially in the case of a personal narrative, they can turn that around same day. So it's increased our ability to bring in complete applications in a timely manner. Also, we are often missing the supporting documentation that is described in each form. And so this is something critical, and a lot of times the applicant will have it in their possession. They just missed uploading it or didn't see that part of the form. So,
is there any hard and fast rule why the deadline is so close? Would it be more efficient to have that deadline earlier, or not earlier, but maybe there's stages or something? Because if folks, there's hundreds of these applications and you only have a limited amount of staff, and a lot of the people who would be submitting their forms, they're tied to other people's deadlines also. Maybe they're in a position they can't get things back right away and they just can't turn it around. So is there a specific reason for that deadline? Could that ever be moved?
It is by rule and it is by statute. So we actually recently got the statute for the filing deadline for our examination applications moved. That was a statutory change that was recently made. It used to be that the deadline, so it's always going to be, the testing accommodations petitions are always going to be the same as the filing deadline for the examination examination application. It used to be that the examination application was due on the 15th of the month before the exam. We have since gained 15 days because of statute. But we don't have the power unless, you know, those rules and or statutes are changed. We don't have the power to change those deadlines. We do a lot of outreach and public outreach and all our, you know, materials that we post online, you know, please, because of the time it takes to process these, and we tell them up front how long it takes, you know, if you have a disability, a permanent disability certainly, you know, and you know about it and you have time, file your application early. They can file it as early as years in advance. You can file it your first year of law school if you want. But a lot, for whatever reason, a lot of applications are filed on the deadline.
As Lisa mentioned, when we have applications that have more than one disability that requires consultant review, it will go to one or more consultants. If the first consultant recommends a full grant of all the requested accommodations, obviously we're not going to forward it on for further review. But so there is that possibility of it needing to go to various people for review. We also have, on occasion, we will have applications in process, and then and maybe even it's gone through consultant review, and we will have an applicant submit a form supporting a new disability with new documentation. And at that point, unless we're already moving forward with a full grant of the requested accommodations, we start the process over to ensure them a full review of everything that they've submitted, as long as it was prior to the deadline. And here, this is just sort of to give you an over idea of the numbers that we've faced over the last couple of years. And we are seeing a steady increase in applications. I don't anticipate that this is going to change. Yeah. Oh, one of the, I mean, when we had the change from the 3-day to the 2-day exam, we saw a large increase for that July examination in the numbers of people applying for the exam, as well as the numbers of people applying for testing accommodations. So that was a big jump, and we were sort of thinking that it might subside a little bit, but it has maintained that increase in level.
So just to conclude, each request for testing accommodations is processed on a case-by-case basis, as Lynn mentioned. And so we don't rubber stamp anything. That is part of why it does take the time that it takes. And some considerations in that review are the need to maintain confidentiality in everything that we do. Everything is on our 9th floor at the San Francisco State Bar office. We process all of that there. It's a locked floor. And diagnosis versus disability. Oftentimes, applicants believe that just because they've been diagnosed with a particular condition, that means that they should or must be granted testing accommodations for the bar exam. That is not true, because the ADA does not require that. The ADA does require us to look at the functional limitations that the applicant has, and that's what you address, not the mere fact that they have been diagnosed with a condition. Also we consider preference versus need. That is what some of our consultants talk about, and that is that there has to be an established need, and that, again, the ADA is that's what the ADA requires, is that the applicant has a need based on their functional limitations and their disability for the particular accommodation that they're requesting for the particular exam and the kind of exam that we're given, essay and multiple choice. And the preference would be, for example, if they've just grown accustomed to doing something or having something that doesn't necessarily mean something that they absolutely need. And so for their disability. And then another consideration would be exam security. We have some applicants sometimes requesting, some applicants with learning disabilities, for example, or reading disorders, requesting a copy of the examination beforehand, before the date of the exam. Well, obviously, we're not going to be granting that accommodation because of the exam security. We can't reveal the contents of the exam prior to the date of the examination. And then lastly, the practicality and the feasibility of on-site administration. We have applicants who request that they be administered the exam in their homes. We can't do that. Certain things just cannot be done with regard to our being able to administer the exam. So that is all that we have for our slideshow presentation. Are there any questions, Robbie?
Lisa, given this recent admission scandal has really hit home how the potential for abuse in this area and the comments of the CBE today during your presentation, do you think that maybe your office could benefit from maybe additional staffing in this area, maybe an RN on the staff or a PA or more? It seems like this, to level the playing field, which is the ADA goal and our goal, I feel like the numbers are high. And as members, you will hear in my presentation with Tammy, the cost to administer an accommodation applicant is 20 times the cost of a regular applicant. I mean, 20 times as high. So I certainly think that it would benefit us to put more resources, Lisa, if you think we need them, in your area to make sure that the applications are compliant with the spirit of the ADA. I don't know. What do you think about that?
Yeah, they are compliant with the processes that we have. That's something that can be discussed internally, but it's, there are this period of times right around the exams when staff is working very hard because of the deadlines that we have and because of the need to get all of these decisions out to the applicants in a timely manner, and also in order for us to be able to, these accommodations, many of them are not just, you give them, you can grant them the day of the exam. They require planning, they require, numbers of proctors, they require hotel rooms. So I don't know if that answers your question.
I just want to highlight that we're going to have a closed discussion where what we want to do is at that session gather, ideas and potential reviews of policies or guidelines related to our process, so that we can either investigate this or come up with recommendations on how to improve our process. So I know that we had a lot of questions about the process right now, but what we wanted to do is make sure that the public were aware of what our current operations are, and then we'll have a more vibrant discussion on potential changes or areas of inquiry.
When we made the recent effort to push back the deadline for filing the petitions, did we get any feedback that would give us a hint as to whether it would be fruitful to try to push them back even more? In other words, there'd be a lot of resistance and it's probably not worth the effort, or do you have any sense of that?
I don't really have any sense of that. I haven't heard any comments. I mean, the various jurisdictions have deadlines all over the place. But I know that, some applicants were complaining because they didn't know about the deadline that had been moved, but.
So, Paul, the main issue is that the application deadline for someone asking for disabilities cannot be earlier than the deadline for someone signing up to take the exam. So those two dates always have to be the same. And so then there's a balance between someone signing up to take an exam. You don't want the cutoff so far that, you're keeping people from being able to know that they have an opportunity to sign up and take the bar exam.
Well, and at some point, if you made it too early, people who just failed the previous one wouldn't be able to apply, but
Right.
is there still a little room in that regard? I guess we are talking about speeding up the process of grading and getting out results. So maybe as we make that quicker, then we can capture some of the time to make Lisa's staff's job a little bit easier.
And it's hard to answer that question in terms of the resistance or the feedback that we received related to the new cutoff, because for the February bar exam, the cutoff should have been January 1st. But given that the law went into effect January 1st, 2019, we allowed we used our old deadline. So we accepted applications through January 15th. For the July bar exam, we did implement the new law, so that the cutoff was June 3rd. So it is the first time that we implement the new deadline. And as Lisa stated, we did have a few applicants. I don't know the head count, but that missed that deadline for a variety of reasons, perhaps being misinformed, but we try to put that out there. We put it on our website. All our publications contained the new dates for some time, but some people fell through the cracks. But I also think that there is a tendency for all our applications, regardless of whether it's testing accommodation or for the bar exam, for people to wait for the last minute. I think that what we try to encourage, and CS Barge will help us do that, our law school assembly, is to just constantly remind deans and students to help us and encourage everybody to just apply as early as possible for all of our any application process that we have in admissions.
Yeah, and people naturally prioritize by deadlines.
And Paul, I just want to also mention that you were concerned about immediate repeaters from the bar exams. They do get a different deadline. They get a little bit later deadline because of the practical aspects of when you get your results from the exam, your deadline has already passed, or at least the timely filing deadline's already passed. So they get different deadlines. Not the final filing deadline, that stays the same, but the timely filing deadline for repeaters is different.
And it's later than,
Yes.
what would it have been for the July exam then, if you know?
So results of the July exam come out sometime around mid-November, mid-November, and so their deadline would be maybe 10 days later.
So January 10th as opposed to the 1st?
Something like that, yeah.
Any other questions for Lisa? Okay, the next item on the agenda, Ravi and Tammy, the report on the February 2019 bar exam cost analysis.
Good morning, everyone. So for the February 19 California bar exam, there is a cost analysis that was attached to the agenda item for everybody to review. The cost for administering the February 19 bar exam was $1,468,000 versus for 2018, it was $1,406,000. For 2019, that was for a total of 5,181 applicants. And for 2018, it was 5,303. The increase in costs that we had from 2018 to 2019 can mostly be attributed to the fact that we had moved to Ontario to try to save cost on the sleeping room aspects for a TA site. However, the facilities out there are limited, and the one that we were using, the conditions were not that great at the hotel. And so with complaints between staff and applicants and proctors, we decided to move our testing accommodation site back to Culver City, where we had previously held it. But because of that, for it being the LA area, that came at a higher cost, so that increased our cost for the February exam. One of the other aspects is we did see some minor increases in audiovisual equipment, which, you know, those are things that we don't really have a whole lot of ability to negotiate because of the fact that those vendors charge what they charge, and they're usually sole vendors for a facility. Approximately 85% of the facility capacity was used for this February exam administration. This was a slight increase from February 18, where we used 84% of the facilities. But for February 18, we did have a slightly higher no-show rate than we did for the February 19 exam. February 19 bar exam historically has consisted with about 85% of our cost contributing from the facility rental, electrical, and the proctors. And as Robbie mentioned earlier, when you break down the cost between a regular site and a TA site, for February 2019, it cost approximately $126 per applicant to administer the bar exam at a standard test center, versus it was $121 in February of 18. And for February 19, the cost to administer the exam per applicant at a testing accommodation site was $2,428 versus $2,337 for the February 18 exam. We did see an increase of about 2.9% in the number of applicants from last year to this year. And lastly, for 2019, we had 353 applicants for testing accommodations that actually tested at the test center. And in February 18, there were 343 applicants. So that's all I have. Does anybody have any questions?
I do.
Yes.
Okay, just looking at this, the graph
Mm-hmm.
that you provided, which is, you know, you look at it and you go, oh my God. For the for the facility rentals,
Mm-hmm.
and then you break it down to tables, electrical, parking, is that facility rental include, like, does this all add up into this, or these are all separate?
Those are actually all separate.
So it's 115,000 for, say, the DoubleTree, and then the parking was 3,700.
Yes.
So that's,
They're all separate costs. So with the facility rental, if, no, never mind, I take that back. The water is listed on there separately as well. So yes, your facility rental is going to usually consist of any meeting space that we're going to utilize, as well as sleeping rooms, any taxes, service charges that come into play with that.
Tammy?
thank you.
Any other questions?
Tammy,
Yes.
mathematically speaking, as the number of applicants requesting accommodation increases, does that also increase the cost for each applicant?
Normally, yes, because the more applicants we have, the more space that we're going to require. However, it also is kind of variable because we don't know what everybody's accommodations are. So, you know, when we can, we try to hold off on increasing the number of like sleeping rooms we're going to utilize until we really get to that point where we see it's necessary. We also, you know, are continuously looking at ways of how we can change our methods possibly to see what we can do to prevent always having to take more space.
And have we ever considered increasing maybe fees for those applicants to offset some of the costs that we incurred?
You know, that's always something that's a consideration and probably on the mind. I know we have not done it for this year, and I don't know exactly how many years it's been since we've done an increase, but that's something that probably will be discussed internally, I guess, to see where we're heading with that.
Just as a reminder, all applicants pay the same amount of money. You can't charge someone with a disability a higher amount of money. Okay.
I figured.
Yeah, Bethany?
There's parking and then there's staff rooms and parking. What's the first parking?
The first parking is for proctors only. proctors and maybe secure off-duty officers, we might include their parking in that. But staff rooms and parking is strictly for our staff for staying at the hotel, and then they charge parking to the staff overnight for staying there.
Got it. So in some of them, the value is zero, so those hotels just let them park.
Yes, there's free parking. So, for example, in July, one of the places we use up north, Santa Clara Convention Center, there is no fee for parking. So that's where there's no cost for that. But we still pay for parking for staff because of the fact that they're staying at a hotel. And so that's a little different.
Any other questions? If not, is there a motion to receive and file the report?
So moved.
Motion and second. Any discussion? All in favor, say aye. Aye. Opposed? Abstentions? Thank you.
Okay.
Ravi?
Next, we have O&M operation and management goals. Tammy has posted those. Does anybody have any questions or comments about our ongoing goals for the remainder of the year? Pretty consistent. Okay.
Oh, I'm sorry. There is somebody in the audience who wishes to.
Oh, yes, of course.
Yes.
Is that it? Okay, thank you. I'll be brief. I know I'm only supposed to be 30 seconds, but I'm also a little bit annoyed.
Would you please state your name for the...
Okay, thank you, and I will forget. My name is James Bloom, United States Marine Corps. I am mentally disabled. These are the three things that are given to me. I'm on disability, and I'm at a disability school because I got shot in the head. The bullet went in and split. I have a problem of recalling things. I can't remember names. I can't do math, but I'm expert in weapons. That's why I'm still in the military. Got my ID and everything, honorable discharge. Let me give you kind of a background. Even though I got shot in the head, I went to school, and under the education code, these are the three things. And I think this man right here asked, how do you know if the person's disabled? Social Security gave me a hearing, and I got adjudicated as a disabled person. Anytime, all you have to say is send in that letter if you're disabled. Boom, that's it. So that covers your question, if it's fraud, okay? So you could start with that. Give me your adjudication letter from Social Security if you're disabled. I am. I have been adjudicated mentally disabled. It'll tell you exactly what the disability is. All the courts, and this is also under the education code, which parallels what you guys are talking about, which I think you're also violating my rights here today, so I think it's important you pay attention, because you actually got a person here who's on SSI disability and collecting it. These are the three things I get, and I'm in school right now, because I'm trying to get off disability. It's called a Disability to Work Program, and I could give you her name, and if you want to give her a call, she works at Disability College, and I can't remember names again, but I got her. She's my, okay, this is the problem. I'm sorry I'm having these blocks, but you got to give me, and this is per the ADA, this is the law, and I'm going to give you that I know. I'll tell you what I know for sure. You have to give me three things. You have to give me a note taker, you have to give me tapes, because I forget. And most of all, this is the pivotal issue that you all have to give me is an advocate. So before, if I was coming for the bar and I want to apply for a license, first thing I'd ask you, if I was disabled, where's my advocate? There are two words that by law you must ask for, an advocate, or it's called an access coordinator, okay? And then when you ask for that, that should be that gentleman's question right there. How do you know if they're disabled? Give me your SSI disability award letter. I got it if you want to see it. Okay, so that should be a dead issue. Then if you want to go after them for fraud, then it becomes a criminal issue, but I'm not going to go into that. So those are three things you got to have. If you guys want to ask me some questions, I'm here to answer it for you, but here's the funny part. Because I got shot in the head, I have a hard time comprehending you. I talk in triplets because I'm searching for the right vocabulary. Even though I got shot in the head and I have an honorable discharge in the Marine Corps, the Army hired me back and I went to school and I barely passed because of my mental disability, but I'm a career counselor. And say I'm fishing for the right words, I'm a career counselor. Then over the age of 50, the Navy called me in because of my expertise. Again, in the Marine Corps, I got it's called 3531 Heavy Equipment Operator. And I served in the Navy Reserves where I got my ID with the microchip, so you can see it right here. So I served in 3 branches. And even though I got shot in the head, I went to California State University of Los Angeles, got my BA degree, even though I have my mental problem. But I went under the education code. You should have that same thing here at the bar, so I'm kind of upset. I talked to Sarah Cohen. She's supposed to give me an advocate here. That is the law, access corner or advocate. You didn't give me that here today at the bar. So again, it's kind of ironic you're making these rules, yet you're violating the rules to me. But that's just my logic. So that's what you have to do, and it's mandatory by law. President Bush signed it, senior, for the ADA with the ramps and everything else. So I need those things. I usually get handouts here. I called Sarah Cohen today. She said there wasn't a meeting here today, but the Army National Guard backdoored her and found out there was. Maybe she don't want me to tell you what I just told you here today. But even
Okay.
you guys here today, in
Could
your
you
presence,
wrap it
you're
up,
breaking
please,
the law.
because we do have a long agenda, sir.
Okay, and, okay, then I'll just leave it at that, but these are the three things you have to give me. I'm still, I don't know who the secretary is here. I usually see her by sight. I've seen that lady before, and she's very sweet, very professional. But there's a secretary here. She's supposed to give me the handout. And I don't have those here today, and that's an example of your service here to me, that you're not doing that. I gave you service when I served my country with an honorable discharge. Thank you.
Okay, thank you very much, and thank you for your service. Any other comments on the,
Anything else on our goals? Okay. Do we need a motion to?
no, I don't think so. There are no
Thank you.
changes, so.
Thank you.
Okay, the next item on the agenda is the educational standards. Natalie and Alex.
Great, thank you. So the first item on the agenda is the report on Lincoln Law School of San Jose periodic inspection. The school underwent its 5-year periodic inspection on October 8th through the 11th, 2018. The school was last inspected in March 2013 and was found to be compliant with the committee's rules and guidelines for accredited law schools at that time. The Lincoln Law School of San Jose offers 4 programs of study, and at the time of inspection had 64 JD students. The inspection team included Esther Lynn, a member of the Committee of Bar Examiners, Justin Atkinson, Academic Dean of San Joaquin College of Law, and the Education Standards Consultant, Heather Georgakis. I've read the report and appreciate the findings of the team. The team found the school to be in substantial compliance with all the committee's rules and guidelines. However, the team identified several issues related to the school's current degree of substantial compliance that must be addressed. But before I open the discussion to the committee, I want to ask if Esther would like to make any comment on the experience.
Sure. It was my first inspection, and I appreciate that the law school made a lot of efforts to have the process go seamlessly. After speaking to the students were generally really happy with what the law school was able to offer, and the faculty and staff were as well. They didn't have much complaints. Based on the recommendations that were made, I understand that the law school has made attempts to implement some of the changes, but not all yet. Also, one of the things that was brought to my attention during the inspection was that the law school is also undergoing the WASC accreditation program. And with that being said, it's my understanding that law schools in general are more apprehensive of the WASC accreditation program in comparison to the Cal accreditation. So I think that's just food for thought in terms of the comparisons of the accreditations.
Great. Thank you, Esther. I'd like to invite Natalie, the Principal Program Analyst with the Office of Admissions, to add any more information or details.
Thank you, Alex. I'll just note that Dean Laura Palazzolo is here, and if the committee wishes to address questions to Dean Palazzolo, she has let me know that she would make herself available.
So at this time, are there any questions or for discussion? I don't see any. There are none. So there's a recommended motion on page 4 with detailed information, but I'd like to open it up to the group. Is there a motion? Des. Is there a second? Great. All those in favor, say aye.
Aye.
Any opposition? Any abstention? Okay, great. That passes. Thank you. Open item 401, excuse me, decision on Lincoln Law School of San Jose request for a major change. That's IP certificate program, the MLS program, and the LLM program. Again, just for some background, Guideline 13 requires that a school must apply for the committee's acquiescence of a professional law degree program and provide any information that the committee requests to assist in the evaluation of the proposal. The school understands the committee reserves the right to terminate its acquiescence under Guideline 13.2, and ultimately the committee's acquiescence decision is not approval of the quality of any such program. Now, about the completed application, seeking acquiescence to the 3 non-JD professional degrees. The first proposed degree is a patent agent certificate. It's a 1-year program that trains candidates who are primarily science majors to become patent agents. The second proposed degree is the MLS IP, a 2-year program designed for those who want to study intellectual property law. The third proposed degree is the LLM IP, a 2-year program designed to assist lawyers and those who earned a law degree overseas to enhance their knowledge of intellectual property law in the U.S. Again, I'll turn to Natalie if she would like to add any more information.
Just context, the school currently operates 3 LLM programs, or master's programs, successfully, and they are in a general area. It makes sense that the school may try to participate in IP programs. Being located in Silicon Valley, there is probably significant need for this type of education in this location.
Yes.
Is this, I hadn't heard of this patent program. Is this one of the first schools that's putting into effect this type of certificate? Is this a new area?
As far as I know, but I think the letter states, at least the school that I read, the letter to us states that it's the first school, but I'm aware Thomas Jefferson also has a similar program. As you know, Thomas Jefferson recently has its ABA accreditation revoked, but we have accredited that school, so that's another school in California that's offering a similar program.
Dean Palazzolo.
I was simply going to give the committee a little bit of background. The school was asked by the United States Patent and Trademark Office to offer the patent agent certificate, and a patent agent and intellectual property clinic exists on site at the school, also at the request of the United States Patent and Trademark Office, which opened its own branch office in San Jose. The school has particular faculty which assists Lincoln students in helping the public to get patents and trademarks on inventions that would otherwise not be available to the public or not be patented or trademarked because of costs. It's expensive to get those things done by a regular law firm. So that's one of the services that Lincoln provides, and in the context of that curriculum, we like to add these degree programs.
Move to approve.
Okay, so is there a motion?
So moved.
Is there a second? All those in favor say I aye. have questions. Oh, sorry. I have several questions about the program. So page 2 of the letter, it reads, one of the qualifications, it's a bachelor degree in certain science, technology, engineering, or math subjects designated by PTO. My understanding is that PTO designated certain degree majors for immediate eligibility to take the patent bar. For example, if you have a degree in electrical engineering or in mechanical engineering, then you're eligible to take the patent bar. For other majors, such as economics or psychology or even computer science, for example, the patent office requires those individuals to obtain certain number of credits in certain engineering or math areas to be qualified. As I'm reading the curriculum, well, first and foremost, a question for the dean, is the qualification for this program limited to the former, or does it also include applicants in the latter?
As a rule, we are simply following the USPTO guidelines, so the application here was a simplification of what the USPTO requires.
So meaning any applicants with any background can apply to this program?
So long as they fulfill the requirements of the USPTO to apply for the patent bar, they are qualified for this program.
So as part of the application review process, do you have a process in place to verify that the applicant has met all of those requirements as designated by the PTO?
We do. Our Assistant Dean of Intellectual Property, Britton Sessions, reviews those applications personally.
And if an applicant comes to you without meeting any one of those requirements, do those applicants turn into automatic rejection?
What we do is we often suggest that they enter into the trademark side of our clinic program so that they're getting intellectual property, copyright information. We're really clear that they won't be able to get a patent agent certificate, but they might get the MLS or an LLM.
But meaning for this specific program, patent agent program, meaning they won't be qualified?
That's correct. Yeah, so they are turned away from the patent agent program.
Got it. Also, on page 4 of the letter to the committee, it reads, the program serves individuals who would like to concentrate their studies in IP, but who don't desire to become lawyers. And then on page 5, I'm looking on the curriculum, by the way, it's well detailed, thank you. It includes things like legal skills 1 and 2, and also contracts and legal research and writing. Given that these courses are mainly for JD candidates who want to be lawyers, what's the mindset behind requiring these courses as part of the curriculum, which is tailored towards non-lawyers?
Right, so the patent agent certificate does not include those.
I'm so sorry, I'm referring to the
Master of
MLS
Legal
program.
Studies, right, and so sometimes people will want to take a our Master of Legal Studies programs are intended to give a general overview and then a specific concentration, sort of like general ed and upper degree levels. And so we have introductory classes that for people who have not studied in the legal fields at all, will give them a background.
Okay. Just sticking to the MLS program you have, on page 6, it reads, as an alternative to the IP Clinic project, students may conduct research on an approved topic centering on either a contemporary legal issue or how IP law may be applied to resolve challenges in society or business. Just focusing on the first part of that statement, where it says students can conduct research on an approved topic, it seems to me that this issue can be non-IP, meaning if so chosen, the student can pick issues relating to areas like tax or securities or even immigration. In other words, it seems to me if we don't further clarify that, it means that a student can literally pick anything outside of IP for their MLS program. Can you explain, if I'm reading this incorrectly, this is the statement stating as an alternative to the IP Clinic project, which is a requirement. Students may conduct research on an approved topic centering on either a contemporary legal issue. Do you see that?
I'm not sure what page you're on, but
This is page, here, let me
I
find
see it, yep.
You see it? Okay.
I'm sorry, what page?
6.
Page 6 of the application, not the letter.
Yep.
As a rule, our alternative sort of capstone projects for those who don't wish to participate in the clinic are supervised by Britton Sessions, who is the IP Associate Dean. And so he would be guiding them to a project that is intellectual property related. I can amend the application to include that, but that's the plan, is that he would be guiding these students.
That would be great if you can amend that, because right now as it stands, it says a contemporary legal issue. It doesn't really specify it has to be IP related, and so I'm concerned that an applicant can basically choose any areas of law outside of IP as part of the requirements. Additional questions. On page 7 of the letter, it reads, except as provided in Rule 4.3 of the mission rules, legal education in a foreign state or country. It's basically a disclaimer. It goes on to read, completion of a professional law degree program at this law school other than for a JD degree does not qualify a student to take the California bar exam. or satisfy the requirements for admission to practice law in California. Now, the language appears to be limited to California bar exam, which may give the appearance that the applicant may be eligible to take the bar exam elsewhere or be licensed in other jurisdiction. So for clarification, I would like to see that it also reads at the very end of that statement, something along the line like, and may not qualify the students to take any other bar examination or be licensed in any other jurisdiction.
If I might respond to that, that is actually currently the California required disclosure, and it is on the list of items to review as part of the rules best practices review this year to provide that a similar type of clarification.
Sure, but can I have this language in the program? That way it further clarifies that people who are taking this program understand that they're not qualified to take the bar exam or be licensed in any other jurisdiction.
I'd like to confer with Dusty.
So I think Natalie's concern is that because the rules and guidelines give the specific language in the disclosure and it's being complied with in this case, that until we change the requirements, it's not appropriate to make that change.
However, it may be appropriate to encourage it as a best practice to the school as part of the discussion.
I only suggest because on page 2 of 0401, second paragraph, I think the staff provided this statement, and perhaps I can recite verbatim. It says the school must understand that the committee reserves the right to terminate its acquiescence under guideline 1.32, I think, under certain circumstances, and also the school must also agree to publicize the required disclosures and compliance terms enumerated in guideline 13.3 and 13.4 to advise candidates that these professional degrees do not qualify students to take the California bar exam or satisfy the requirements for licensure in California, and may not qualify students to take any other bar exam or be licensed in any jurisdiction. So this is, I don't know if this is a recommendation, but this is also in the background. So are you recommending that, or are you not recommending that?
As to the LLM, recommending the disclosure that's attached to the LLM. As to the degree in general, there's actually that broader type of disclaimer that you had highlighted there.
Can you point me to it? Because I see the first part of that recommendation, I just didn't the second part, so perhaps I might have missed it.
I would be happy to do
I can
so.
point you to where the language is. This is on page 7 of the letter. And again, it appears for the LLM program on page 9. So you can refer to those 2 pages.
I'm sorry, on the letter, you're on page 7?
Yeah, on page 7, required disclosure for a professional law degree.
If I'm reading it right, I'm sorry, it appears to be in there. It says, Lincoln acknowledges the following disclosure will be required to be included, except as Rule 2.3. It says California bar exam or to satisfy the requirements for admission to practice law in California. It may not qualify a student to take the bar exam or to satisfy requirements for admission to the practice of law in any other jurisdiction. So I think we copied the language correctly.
I think you may be correct. So in that case, that language is in there. So in that case, I think the school is going to go with that language.
That's correct.
Which is great, by the way.
In both cases, we.
Okay. I don't have any recommended revisions other than the one that I just talked about, but I do want to give you my encouragement, but this program is very important, especially in Silicon Valley. So kudos to your team for coming up with a program in conjunction with the PTO to help students get certified.
Thank you.
Are there any other questions or anything else for discussion? So I want to revisit again the motion. There's a staff recommendation to approve the school's 3 major change requests and acquiesce to the school's plan to offer the 3 requested programs effective immediately. Is there a motion?
So moved.
Is this the motion as written, or can we amend the motion to include additional contingency per our discussion just now?
Per what you just said.
Okay, so subject to the additional revision as recommended by the committee. in that case?
Yes.
Okay.
All those in favor, say aye.
Aye.
Any opposition? Any abstention? Thank you.
Thank you.
Open item 402, report on application materials to address amended rules and guidelines for accredited law schools related to distance learning. Just for informational purposes, this is the law school accreditation application. Under rules ratified by the Board of Trustees, schools may propose JD programs that are fully online when seeking accreditation. Natalie, do you want to provide any more information?
Sure. Just a brief background. This is in fact the primarily the item that the committee reviewed at its last meeting in April. Since that time, it was put forth through the proper paces, taken to the Board of Trustees for final ratification as to the rules and guidelines. And in addition, the application being in the hands of CS BARS for a time, we received very helpful feedback from CS BARS that adjusted not the substance, but the clarity of the application to make it easier for the schools to access this application. So at this time, the State Bar is prepared to post and release the amended guidelines for accredited schools and accompanying rules, as well as the application for registered schools and permission for accredited schools to apply to expand their online programs via major change. It is expected that in the case of the registered schools, an email with this application will be sent to all registered schools, whether or not they've so far expressed an interest in accrediting, so that they may have this information and decide whether to pursue accreditation. And as for the accredited schools, they would submit through the standard major change process.
Great. Thank you, Natalie. Are there any questions, any discussion? No? Okay, great. So the next item, open item 403, decision on law school petition for reconsideration of waiver of 84-month rule for student. Natalie, are there any handouts for this one that we wanted to give to members?
This was received via email by the committee. There are redacted copies of that item available for anyone who may wish to see that with the name of the school and the name of the student redacted.
Great. So,
Yeah, so can I just remind everyone that we're doing this in open session because there is no exemption to hear this kind of a petition in closed session. However, it does concern somebody's private medical condition. So in order to protect your privacy, we request that people not refer to the law student by name or the law school by name.
great. Thanks, Destiny. So we're going to does anybody want a copy of the redacted, the not redacted version? You, like Natalie mentioned, received it by email as well, but I'm just going to read some background on it. The law school seeks reconsideration of the Committee of Bar Examiners' denial of the school's request to waive Guideline 6.5A. Guideline 6.5A requires that all students at California accredited law schools complete their JD degree requirements within 84 months. The guideline already incorporates time for students to repeat courses or take a leave of absence while still completing the requirements within the 84-month limit. The law school seeks reconsideration of the original decision on two grounds. One, reconsideration because the committee's vote was divided and close. And two, the law school asks that the committee review a form that the student used to request a medical leave of absence. Is there any additional background information, Natalie, you would like to provide?
No, thank you, but I'm available to answer questions.
Great. So I'd like to open it up for discussion at this time.
Now, I want to make sure this was already before the Committee of Bar Examiners.
Yes.
What is new about what is before the Committee of Bar Examiners today?
At this time, the school submitted the fact that the vote was divided and close. It also submitted some medical records that concern some conditions that were discussed, and those records would have existed at the time of the prior hearing.
But they were not, we discussed medical conditions, but the records could have been presented to us, but were not.
Yes, that's correct, and they were not requested by the committee at that time or after that discussion.
Okay, I don't see any reason to change the committee's vote based on that little, well, really, nothing new about it, so that's my feeling.
Thank you. Any other questions or comments? So there is a recommendation that the law school's petition for reconsideration be denied, but is there a motion? Is there a second? All those in favor say aye. Aye. Any opposition? Any abstention? Thank you. Let's see, open item 404, notice of new administrators at registered and accredited law schools. There are no changes to report. Open item 405, the stated goals for education standards. Everybody has a copy in front of them. I would like to make note of goal number 2, that the first issue of the quarterly newsletter was distributed to law school deans in May 2019 after meetings commenced for the Law School Council and the CS bars. But again, I'll turn it to Natalie if you want to provide any more information about that in particular or any of the other goals.
I appreciate the completeness of your report. Thank you, Alex.
Any questions, comments? Thank you.
Thank you. The next item on the agenda is under moral character. Mark, are you leading this one?
Yeah, thank you, Jim. Good morning, everyone. This is an agenda item that seeks the CBE's approval of guidelines for conducting administrative reviews of adverse moral character determinations. The committee may recall that in September of 2018, the Board of Trustees provided that that staff will in the future conduct informal conferences with the Committee of Bar Examiners acting as an administrative review body of adverse moral character determinations. The admissions rules have been revised to accommodate that new procedure, and those rules are now pending before the California Supreme Court for approval. But in anticipation of the approval of those rules, staff has drafted the attached guidelines and procedures for the CBE's consideration of petitions for review of staff determined adverse moral character determinations. So the rules, as you can see on the attachment, are fairly straightforward. They do provide for the content of the petitions as well as the deadlines for submitting the petition, as well as some guidelines as to when the CBE's review of those petitions should occur. In addition to that, there is these administrative reviews should be are sort of contemplated to be on the record. There is a guideline that provides that the CBE can in fact initiate a second informal conference in exceptional circumstances. That would be within the discretion of the Committee of Bar Examiners. So if there are any questions, I'm happy to, I see hands. Bethany?
Yeah, I just had, so on the procedures, on attachment A, number C lays out what has to be included in the request for an administrative review. And number 1 says describing the alleged misconduct at issue. Is that the applicant's alleged misconduct, or is it that they have to allege that the staff committed some misconduct at their first hearing?
No, we're looking at the content of the petition, and we're asked, that applies to the misconduct of the applicant, the wrongdoing, that matter that's at issue by the applicant.
Okay.
Okay. Paul?
So following that up, is it always misconduct, or are there other things that could be issues? I'm just wondering if that word is a little bit too narrow.
It might be, misconduct is sort of our general term of art that we use on a generalized basis. Happy to
But that's kind of
consider
internal to the
additional-
bar, so maybe if we could use words that are clearer to law students
Okay.
and applicants. And then in paragraph E of the attachment, it says one of the members of the panel needs to be an active California attorney. What's the rationale for that? Is that a requirement of the rules that this is implementing? Or?
Well, first of all, I think maybe the idea behind the participation of a California attorney is to sort of utilize and exploit that particular skill set that attorneys have. Right now, it is a policy when we handle informal conferences that there be a member of the bar who to participate in those informal conferences. That's what happens now. Now, I do understand that perhaps the word active can be changed to member, for example, so that there may be individuals who are members of the bar but are presently inactive. So
Yours truly.
there you go. And I think Jim may be another one of those. So that can also be a change. So perhaps the word active can be removed and we can just put in a member of the bar in order to accommodate that.
Yeah, because I think if you just leave active in, it's also not clear if you're speaking in terms of bar membership or just somebody who's practicing law as opposed to has their active license but is doing something else.
Yeah, no, we can make that change. So
Okay.
are you okay with changing active to member?
Member, that'd be fine with me.
Fine.
I wonder if that's going to give us enough flexibility to create these subcommittees, though. Do you anticipate a problem that you won't be able to muster up for scheduling reasons an attorney to serve on each of these committees?
But also, though, if I may interject, one of my concerns is if there are only 2 members, only so that's designated, would that create any conflicts when or where each member has conflicting opinion or reach divergent results? In that case, how do we resolve the difference when you only have 2 members making the decision?
Well, I guess they're making a recommendation to the full committee in any sense, so you'll bring in more heads at that point. So in
That's
other words, they have to tee up the issue for the full committee. They don't decide it at their level.
Yeah, and in fact, we've had, I think it's sort of the rare instance when we have, when the members on a panel can't reach a consensus, even if it's 2 members. But you're right, Paul, that, that there is a sort of an unresolved difference of opinion that can be brought to the full committee for consideration.
And actually, the discussion of that will probably make the full committee's consideration more robust and easier than if they agreed.
I agree.
And I think
Okay.
you also had asked if we thought asking for 2 members, I'm sorry, if 1 member has to be an attorney, if that would create any scheduling issues. So since that is the current practice with informal conferences, I don't think it will be going forward since it's what we're already doing.
Okay, thank you. And then in the next sentence of that paragraph, it refers to the record will include the informal conference recording, if any. And I wonder if is that talking about whether there was an informal conference or suggesting that not all informal conferences will be recorded?
No, that does not suggest that all informal conferences will be recorded. If there is in fact an informal conference, they are recorded by rule. And there are instances, for example, when an applicant is denied because he or she refused to attend an informal conference. We give them 2, 3 opportunities to participate, but if they don't at that point, they're placed on the what we call the C-501, sort of other moral character decisions to be made. So not all adverse determinations are. Most of them are result from an informal conference, but not all.
Okay, but there is a rule somewhere else that says they have to be recorded if they occur.
Yes, and
Okay.
that's an internal policy.
Should that internal policy be reflected in this guideline then?
You mean in this guideline?
Yeah.
Oh, I suppose we could add.
Yeah, because that's an
the-
important point, I think, for some of us was that, you know, we're upset that we're not going to be there at the informal conference to judge the credibility. And so carrot, well, fig leaf or whatever was offered that, well, they'll be recorded, so at least we can listen to it. So
Right.
I guess I want to make sure that that isn't optional.
Yeah, well, it is. I said, just to reiterate, every informal conference is recorded.
But it's just an internal guideline. It seems to me it should be memorialized in this thing, but that's my opinion. I'll move on. Then paragraph F begins, within 60 days of receipt, the committee will conduct a review. And in the context of the whole here, this is the only deadline. So it kind of confuses me. For instance, let's say the subcommittee, I guess, is supposed to finish their review, but then there's no real clock running on the rest of the operation to finish up its part. I think it's difficult to set those deadlines, but I'm just wondering how helpful it is to set this one particular one and no others. I'll just leave that as a question for you.
Yeah. So what you're suggesting, Paul, and correct me if I'm mistaken, is that after the 60-day period, hopefully we'll get that review done sooner,
Right.
for the benefit of the state bar as well as the applicant. So your suggestion is to add another provision in here, at least a sentence that indicates when the committee itself will make that determination or will consider it, perhaps at the next scheduled
And
CBD
actually-
meeting, something of that nature.
Actually, I also highlighted it. In paragraph G, it does say the panel will present its findings to the committee at the next
There
regularly
you
scheduled
go.
meeting of the committee.
Okay.
Maybe, but it's not clear what next relates to. Is that next committee meeting following the filing of the appeal?
I think it would be
or-
the next committee meeting following the panel's consideration and determination. So,
Okay. All right, so maybe that's okay. It seemed a little vague to me. And then finally, in paragraph H, it says that notices of denials will be sent by certified mail with proof of service, but I think it's, the post office uses another term, it's receipt or something.
yeah, this is standard language and language that we have now. The reason for it is because this begins to clock for filing the appeal to the State Bar Court. And there has to be some evidence that proper notice was given to the applicant of the adverse determination in order to prove that they were within the time period for filing the petition to the State Bar Court. So that's
Okay.
the purpose of it.
Well,
And that's the
and-
standard language that we have now.
Yeah, I'm just wondering, normally people would say, I think, certified mail return receipt. And then your proof would be that you had that return receipt in your file to show that somebody actually signed for it. So I just offer that as maybe even better than, because your proof of service is just going to be a statement that we put it in the mail.
Right, yeah, that's right.
Without the follow-up.
Right.
It just, odd things set me off, and that's one of them. And I'm
Okay.
done.
Thank you.
Back on the issue of the statement about one of the two committee members being an attorney to review the appeals. On the first go-around, with the new procedure, with staff reviewing the moral character applications to begin with, how often will an attorney be part of that?
With respect to staff reviews or staff conducted informal conferences, an attorney will be present at every one of those. We in fact hired an attorney in moral character. His name is David Lane, And he joined us, so what, about a month ago? About a month ago, and he was, so he will be the attorney representative of staff to participate in those informal conferences. And in the event of his absence, then, you know, we have other attorneys in the office, myself included, you know, who, with the approval of the director, can also participate in the absence. But the rule that we're implementing is that in every informal conference conducted by staff, an attorney will also be part of that procedure.
So that attorney, the new staff attorney, will be playing a more active role in the moral character interviews than, for instance, you have in the prior process where the committee members were primarily making the decision with you being.
Yeah, and that's correct.
Sorry, can I just clarify that? But Mark, you were sitting in the informal conferences as a program manager, and now we have Tara Clark as a program manager, and she will be participating in those informal conferences.
Yeah, thank you for that, Amy, because yes, the attorney who was actually participating in the informal conferences in the current and prior procedure was a member of the CBE. Right, and as Amy is saying, I was participating as staff and was not an active participant in those informal conferences.
Question.
Oh, go ahead.
Go ahead, Robbie.
Okay. Maybe I missed that. What is the informal conference procedure going to be? I don't know. How many people and who are they, and have you established that procedure
Yeah,
yet?
we're in the process, and we have written as far as the internal process for staff handling informal conferences. You know, those have been drafted, and you know, we're reworking them. But yes, we've prepared some informal guidelines, informal conference guidelines.
What is the? I've heard you just say there's going to be one attorney there.
One attorney and the program manager will be a part of, that's Tara, will be a part of those informal conferences, as well as the investigator who evaluated investigated the case. Those will be the participants. Did I miss anybody?
I believe the proposed procedures right now would also give the option for one of the program supervisors to sit in.
That's
So
right.
It's very similar to the makeup of the panel currently, where it says 2 to 4 members. So our goal will always to try to have 3 people, just to try to avoid that, the potential conflict. But 2 to 4 is how it's written.
Because I think the dynamic of having 3 or more, as we do now, is really helpful for when we talk about applicants. And I think a lot good happens when you have a lot of minds, kind of the way it's set up now. But that is the plan, that it's going to be a similar number of decision makers, not observers or managers, but people that are going to be deciding whether the person should pass or what should be the bar to passing. That's the idea, to have 3 decision makers like we have now.
The idea, right now it's drafted, it's 2 to 4 members.
So one would be a lawyer who goes to all of them, and the other would be, rotating staff?
It depends on who's available, but yes, the program manager or a program supervisor or an investigator.
And the lawyer that just got hired, is that lawyer going to be going back and forth to attend both Northern and Southern? So the staff will change at each conference, but the lawyer will be the same?
Well, ideally, it'll be myself and David will be traveling back and forth, and then just the third member of the panel would be possibly rotating. So we have 2 program supervisors. The second one is starting in July. It's someone that was previously in the moral character unit, as well as then, like Mark said, the investigator on the case would rotate. So we would be the main people that would continue to go back and forth. So
I see. Okay, thanks.
Question, since this is an administrative review, is there a standard of review governing this process? In other words, is there sort of things like a de novo, or should we afford deference to the staff determination and review based on only abuse of discretion?
Yeah, well, that's not identified here. We haven't had in the past a sort of a determined standard, certainly in state bar court proceedings, in moral character proceedings, as well as disciplinary actions. That standard is clear and convincing.
So I guess what I just want to know is whether there's going to be forthcoming clarification as to how we should review and to what extent we can review the record in either overriding or agreeing with the staff determination.
Yeah, we can, if you, I suppose if you wanted to adopt the clear and convincing standard, that's consistent with the state bar court proceedings, I suppose you could do that.
OTC, any comments on that? In terms of standard review governing this admonition?
I don't. I can certainly look into it if you want me to present something on it.
Yeah, I think it would be important for the committee to understand how we should look at the record. I mean, I think this is essentially, since this is an administrative review, I think all of us need to understand to what extent we can look at the record and whether we can only look at certain types of decisions made. And so I think it is important to understand the standard review governing this process.
I'm just curious as to why it would change significantly from how we do it now. I think what we're trying to do is parallel what our current process is in terms of appeals. So if you consider how we look at appeals now that come in for moral, or how an informal conference is conducted, we're creating another appeals process, but how does it differ, for example, when we have a decision made by like an informal conference, we bring it to the full committee to discuss? Wouldn't that parallel what we're trying to attempt here?
Well, I think in this case, the staff has already made a determination. So, I mean, we just want to make sure that we understand, again, the standard in terms of reviewing that decision. I think here, currently, we make the decision. The subcommittee makes that form of decision, whereas going forward, the staff will be making the decision based on whatever records and evidence that they so choose to review. So in that sense, should we limit ourselves to only evidence reviewed, or can we look at the entire record de novo so that we understand the full records in its entirety, which will make a difference at times.
Yeah. That's something perhaps we can explore and think about, more. I understand your point.
Yeah, the difference, the key difference also, keep in mind, is that the committee members are only going to hear, quote, appeals. They're not going to hear decisions that the applicant did not appeal. So just so you're aware of, that's a critical difference. So in other words, if the staff made a decision and the applicant's happy with the decision and it doesn't come to the committee, then, it's like a tree falling in the forest and nobody hears it. It doesn't make a noise. So just something, to be aware of. I personally am comfortable with that because I have confidence in the staff's ability, and I think that our role is to be an appeals body. But just so folks understand that that's how it's going to, that's, in my opinion, the real critical difference going forward. And I think I think it's a good idea because I think we're going to see more consistency.
Bethany?
Will the attorney be coming to the meetings when we do hear appeals to discuss what he and or she observed at the informal conferences? Because you know how sometimes when you read it on paper, that's why the credibility is really important, because on paper somebody could seem totally crazy, but in person, they've exhibited that they're rehabilitated or whatever. So I'm wondering if he's going to be coming to be able to speak to us about what he observed.
You're talking about the moral character attorney?
Mm-hmm.
I think that's something that Amy and Mark and I were discussing, but I think initially the intention is yes to have him here, but I think we just have to confirm with Amy.
Okay.
Partially on that issue, it's my personal impression, and I don't know how the other members who have served on the moral character committee feel, that the person, the analyst who puts together the report for us can't help but become less than objective in that process. Sometimes reading the analyst's report, I could guess whether the analyst feels this person is of sufficient moral character to become an attorney or not, just by the read. Just like the same way that anthropologists are not objective. There is some amount of subjectivity just in the process, I think, of pulling that information together and seeing it in writing, because as Bethany said, sometimes what you see in writing is very different than what appears to you in person when you conduct the interview. So if the analyst is going to be one of the people being a decision maker, I think that you need to be careful in making sure that what happens is the analyst not coming in to the interview ready to put forth their opinion, regardless of what the interview turns out to be. I would almost suggest that the analyst not be one of the decision makers, because right now the analyst is not a decision maker. The people that the committee comes in fairly fresh, having read the information, but not having lived with the process of the back and forth communication to the applicant saying, you have not submitted this, you have not submitted that, and I don't know if I've made myself clear, but that's my opinion.
Yeah, I appreciate that. One of the advantages of having the investigator participate is the in-depth knowledge that the investigator, in fact, will have in connection with that particular investigation. And what we're trying to do is, take advantage of that in-depth knowledge, of the matter. And also bear in mind that what we do intend is some robust training of the moral character staff who may be participating in these informal conferences with respect to how to conduct themselves, how to ask questions, and the parameters on asking questions, so that that in fact the integrity of the informal conferences remain, and we're confident that it will.
I have and this might be really hard, Mark, for you to answer.
I'll do my best, Larry.
Do you think the applicants are going to understand that there's now a sort of a difference in the process, because they're going to be doing informal conferences with staff as opposed to with members of the committee, and that might change? They might say, oh, well, now I've got another step. I can actually appeal. And there might be more, you might see more appeals of the decisions.
You're right. That's a hard question to answer. I can't predict whether or not there's going to be an increase in appeals or not. I think only time will tell, Larry. So I wish I had a crystal ball, but I don't.
Yes.
I support what Paul said about the comment with the informal conference recording, that I think, if any, should be struck, and it should always be an accepted form that informal conference will be recorded and incorporated.
We can add that to the guidelines.
Other comments? It sounds like you have some revisions to make in response to the comments that have been made.
That's the impression I'm getting, Jim.
Yeah, so I would suggest that we re-agendize this for our next meeting to finalize.
Okay. Oh, that we can do. Thank you very much.
Okay, thank you. And the next item, Bethany, is the discussion of the 2018-2019 moral character goals. Are there
Yeah, so these are just our ongoing goals. There were a couple of revisions made from last meeting because some people had some issues with some of the wording. And so Tara has gone through and made those changes. But otherwise, these are the goals. Anybody have any discussion on it? All right.
Since there have been changes made, it would, I'd suggest that there be a motion and a second. to
Okay.
adopt.
Do we have a motion to approve the goals? Patricia, a second?
Second.
Second. All in favor?
Aye,
Any abstentions?
and
All right.
nobody opposed.
And nobody opposed.
Okay, thank you. I think that concludes our open session. So let's see. I don't know whether or not the food is here yet. It is here? Why don't we take a break then until 12:15? We will reconvene at 12:15 in closed session, and the remainder of our meeting will be closed session. So, thank you.